Yeah. A very warm good evening to our chief guests, and all the wonderful audience present here. It's my pleasure to begin this auspicious occasion by heartily welcoming everyone. I, Karan Arora, on behalf of GD Goenka University, warmly welcome one and all present here to the valedictory ceremony of 4th GD Goenka's SIAB India International Virtual Commercial Arbitration Moot Court Competition 2020. Now, I request Professor Dr. Tabriz Ahmed, Vice Chancellor and Dean, School of Law, GD Goenka University, to kindly deliver the welcome address. Sir, please.
His Excellency Honorable Dr. Michael Wong, Dr. Lalit Bhasin, Dr. Sukku Bhaskaran, Directors, Deans and Heads from various schools and departments of our university, member of the organizing team, media partners, knowledge partners and sponsors of the event, distinguished guests, my faculty colleagues, dear participants and most lovable students, ladies and gentlemen. I welcome you all in the valedictory function of the 4th GD Goenka CIR International Commercial Arbitration Moot Court Competition 2020. It is a matter of great happiness and pride for us that the 4th GDGU CIR International Commercial Arbitration Moot Court Competition has become a great grand success. We welcome His Excellency Honorable Dr. Michael Wong, one of the very well-known arbitrator luminary in the world. He is a very humble and real gentleman that even from his busy schedule, as well as on a short notice, he accepted our invitation to be the chief guest of the event. Please join me in welcoming Honorable Dr. Michael Wong. We welcome Dr. Lalit Bhasin, our co-host of the event, a great intellectual leader and passionate to develop the standards of the legal profession in the country. We thank Dr. Lalit Bhasin for his wholehearted support for the event from the last 4 years. We also welcome our own president, Dr. Sukku Bhaskaran, a well-known academician par excellence. He is always supportive to any kind of new ideas and promotion and development of the university. We welcome all the distinguished guests, members of the organizing committee, participants across all the top law schools of the country, and judges from all over India and other foreign countries. In fact, we had 60 budding arbitrators grilled by 44 excellent judges to bring out the best. We welcome all the deans, directors, heads, colleagues, students from School of Law and other schools and departments of our university. We also welcome to those who could not join the Zoom due to limited capacity and attending the program on Facebook Live. We are committed to clinical legal education and raise the standards of legal education in the country. And this arbitration moot is the part of the process. We thank all judges and participants of the 4th International Commercial Arbitration Moot Court Competition. You are the real winners, and I am sure it has a lot of value addition to your life. Your presence is not only an honor for the School of Law, GD Goenka University, but also provides a motivation and confidence in continuing the journey of legal excellence. I welcome Dr. Michael Wong and you all once again in the valedictory function of the 4th GD Goenka University CIR International Commercial Arbitration Moot Court Competition 2020. Events like this scale cannot happen without dedication and hard work. Our Moot organizing committee was working very hard for several months. Please give a big hand to the entire arbitration Moot Court committee for the successful organization of this event. Please take care of yourself and your family in this difficult time of coronavirus pandemic. Thank you so very much.
Thank you, sir, for your kind words. I would now request our Honorable President, Professor Dr. Sukku Bhaskaran, GD Goenka University, to kindly share his thoughts with the audience. Sir, please.
Thank you very much, Karan. It's a pleasure being here. And congratulations to Professor Tabriz Ahmed and his team who put together this. And I hear that it was a resounding success. It's excellent. I also welcome Dr. Lalit Bhasin, whom I've already described as a friend of the university, particularly the law school, and Dr. Michael Huang, who the only thing I know about Dr. Huang is that he's speaking here today and that he's a well-known in legal circles, according to what Professor Tabriz said. Welcome to our university, though virtually, Dr. Huang, and I hope sometime you get an opportunity to come and visit us as well. Now, Let me see. Okay, I've already done the congratulations. Now, this project obviously entailed quite a bit of teamwork, and I'm happy that the school has demonstrated great collegiality and teamwork in putting together not only this, a number of very fabulous events under the leadership of Dr. Tabriz Ahmad. It's, as I said again during the opening session, the school has started to accelerate in many areas and has beginning to demonstrate that we will in the forthcoming few years have a very good legal school. And I think we have got the fallback positions of people like Dr. Lalit Bhasin, whom I again say that is a friend of the university, particularly the law school, and they would form very good mentors to Professor Tabriz Ahmad and his team. Now, I also recall that about 2 years ago, Dr. Bhasin, when we had this function at the Hyatt, I remember in your address you said that Indian law schools tend to overly focus on oral communication skills and that we should also develop written communication skills. So just prior to this, before coming on, I just did a little bit of search and I noticed that there has been some survey conducted among British legal students and they too rate written communication skill as their #1 requirement. They've stated that as being #1 because as a prospective lawyer, you would of course have to have skills in legal writing that would include things like contract drafting and the ability to be brief and accurate in your writing and writing using legal vocabulary. So there is a big area that we could perhaps also explore the possibility. And organizations such as the British Legal Center runs these type of courses. If you talk of branding, Professor Tabriz, this would be a good sort of activity where people in the profession and prospective legal students can get to know about our legal school through activities such as this. We should begin to do activities that are not atypical that is being done in other schools. But you need the time, you've just come in, and I think the work you're doing is fabulous, and I'm really, really happy that, that we've got you on board. I congratulate the students and the team members for having done a great work, and with that I will end. Thank you very much again, Dr. Lalit Bhasin and Dr. Michael Huang. As I said, I was born in the country just next door to yours, and at that time when I was born, it was one country, by the way. Singapore and Malaysia were one country. Okay, all the best. Thank you.
Thank you, sir, for your kind words. I would now like to introduce Dr. Lalit Bhasin, Senior Advocate of the Supreme Court of India, President of SIAB India, and Chief Patron of GD Goenka International Virtual Commercial Arbitration Moot Court Competition 2020. Now, I request sir to kindly share his thoughts with our audience. Sir, please.
You're muted, Dr. Lalit. You have to unmute.
Yeah, I'm sorry. I have had the privilege of knowing Dr. Michael Wong, I think for the last 4 decades, both in Singapore as well as when he was the Chief Justice of Dubai International Financial Center based in Dubai. Dr. Michael Wong, he's an institution by himself so far as the field of arbitration is concerned. And he's done pioneering work, great work in the field of promoting international arbitration, both in SIAC in Singapore and also in DIFC in Dubai. So it's a great honor for all the participating teams here, all the faculty members from all over India and the GD Goenka Institute to have a person of His Eminence, that is Dr. Michael Wong's eminence, to be here as the chief guest and to deliver his valedictory address. At least I am privileged to share this platform with Dr. Michael Wong. The GD Goenka University is to be complimented, as also the law school under Professor Tabriz Ahmed, for organizing this unique event, which is the fourth International Virtual Commercial Arbitration Moot Court Competition. And what impressed me most was the problem, that was the proposition, you see, which was given to the participants. It was something different, something unique, which required a lot of hard work and research on the part of the participants. And I must say that judging the final round, I came to the conclusion that they have done an excellent job. All the teams, you see, who participated, they have done a great job. So please keep on doing this. I'm requesting, you see, Professor Dr. Sukku Bhaskaran, who is the president of the GD Goenka University, to please keep on promoting such events, not just in the law school, but in the other areas also. Because what I feel is that a lawyer is not complete just by reading the law books. I think he has to also diversify his knowledge on a contemporaneous global development basis. A lawyer will not be a good lawyer just by reading the Contract Act, you see, or the Arbitration Act. He needs to enrich his knowledge of what is happening around. Therefore, whenever I visit the law schools, and I visit at least 2 law schools in a month all over the country, I always tell the students that, yes, do your research. You have the tools now available, but also keep yourself abreast of the developments which are taking place in the field of literature, in the field of history, in the field of commerce, in other areas like engineering and all those things, you know, like you have the Petroleum University in Dehradun. They are doing a great job in combining law with the other activities, other disciplines, you see. So that should be done. Diversification of law should be attempted, you see. If not officially recognized by Bar Council, you can do it on informal basis on your own, for which you don't need the permission of the Bar Council of India. So it has been a great opportunity for me, a learning opportunity, and learning also from the students, you see, because they participated very effectively. And I must compliment the faculty not only of the GD Goenka Law School, but faculty of all the law schools which participated in this event, for sending their teams and guiding them, you see, to participate in this tournament. As I keep on telling the law students that you may do your research, you have, you see, all the tools available, but must remember that there is no substitute for a law teacher. You will always need a law teacher. You cannot learn law just by looking into the law books. Therefore, this able guidance given by the faculty members, I think, is a great contribution by the teaching faculty to the legal education, and that needs to be promoted and strengthened by all the universities, by all the managements of the law school. And Professor Dr. Sukku Bhaskaran rightly pointed out that I have been pleading for promoting legal writings. You see, any oral submissions that you make in the courts, they also have to be based on your written submissions, the pleadings, you see, the way you draft. Therefore, proper attention is to be made. And I suggested to some law schools, and they have implemented, that let there be, you see, an essay competition on a subject given. And this is the right time when you are having this virtual thing going on, that you can organize the essay competition where you give a theme, a topic, and give them time, you see, of an hour and a half to write that, and to send those submissions to a panel of judges who will judge that. So promote legal writing also as a subject. And with these words, I compliment all the teams. I congratulate all the teams. To me, no one team is winner. For me, all the teams are winners because they have been selected by their respective institutions to represent them in this competition. Therefore, in a way, everyone is a winner. But yes, someone will be number one, someone will be number two. But I think that everyone would share the glory of this competition, which has just finished now. And it will officially finish after we have a person of Dr. Michael Wong's eminence to give the valedictory address. So my thanks to all of you. Thanks to the participating teams. All the best to them, all the blessings to them. And over to you, Karan Arora.
Thank you, sir. Thank you, sir, for motivating us with your thought-provoking speech. I would now like to introduce His Excellency, Honorable Dr. Michael Wong, currently practices as an international arbitrator and mediator based in Singapore, with a selective practice as Senior Counsel of the Supreme Court of Singapore. He served as the Chief Justice of the Dubai International Financial Center, DIFC, courts from 2010 to 2018. Michael's other past appointments include Judicial Commissioner of the Supreme Court of Singapore, Singapore's non-resident ambassador to Switzerland and Argentina, President of the Law Society of Singapore, Commissioner of the United Nations Compensation Commission, Vice Chairman of the ICC International Court of Arbitration, Vice President of the International Council of Commercial Arbitration, visiting and later adjunct professor of the National University of Singapore. He was educated at undergraduate and postgraduate levels at Oxford University, where he won a college scholarship by open competitive examination. He has been conferred an honorary LLD by the University of Sydney. I now request His Excellency, Honorable Dr. Michael Wong, to give the valedictory address. Sir, please.
Thank you, Karan.
Thank you.
First of all, may I thank the university for extending this very kind invitation to me, which I greatly appreciate. Secondly, I particularly appreciate on a personal level the remarks made by my longtime friend and colleague, Mr. Ladid Basin, and I'm happy to see him so well after so many decades, as we have not seen each other for a few years, but it looks like just yesterday. So I'm pleased to be back virtually in India again. The title for tonight's address for me is The Need for Appreciation of Cultural Differences in International Arbitration. And this arises because the players in international arbitration are a mixture of nationalities, cultures, and legal traditions, and even of different levels of experience of international arbitration. So the tribunal needs to factor those in to achieve a harmonious and profitable engagement between all the players led by the tribunal. The object is to make all the users feel that they have a full opportunity of participating in the development of the arbitration at every stage and not feel discriminated against because some parties are from different heritages and backgrounds, even when we are theoretically aligned on basic legal norms for the running of the arbitration. Those norms will include the governing law, the seat, the applicable rules of evidence, and disclosures of interest. There are still many unwritten situations which need ad hoc solutions. So it's a constant concern for international arbitrations to avoid any party feeling discriminated against because of extraneous factors. So I will break this talk down by analyzing the need for cultural differences at 3 levels. The first will be at the tribunal level, the second will be at the council level, and the third will be at the witness level and the party level. So let me first deal with the tribunal level. You cannot assume as an arbitrator that when you have, and I speak as a common lawyer, as all of you are, you cannot assume that civil law arbitrators reason like common law arbitrators. To give you one very concrete example, I was sitting as chair of a tribunal seated in Hong Kong. If I recall correctly, the governing law was Korean law. And because that was the governing law, my co-arbitrator and I decided to choose a civilian lawyer to be our chair. And we chose a Swiss arbitrator, very distinguished. And he was in charge of the procedure. So when the first witness came, there was examination in chief, which was largely just affirming the witness's witness statement and a few supplementary questions. Then, of course, there was cross-examination. And after cross-examination, there was re-examination. I believe everyone here listening to this lecture will be familiar with that common law tradition. Our Swiss chairman then said, I will now allow re-cross-examination. So we had a break at that point, and we asked him, why do you have this re-cross-examination? We have not heard of it. He says, look, I look at it as a civil lawyer. A civilian lawyer says you must have equality on both sides. So each side must get 2 bites at the same witness. I mean, it was very logical. And of course, if you ask a common lawyer, there will be some historical reason why we have done it this way for so many years. But you just have to appreciate that not everyone who is just as intelligent, if not more so, than you, can share the same very basic approach to the way that hearings are run. Secondly, there is a major gulf between common lawyers and civilian lawyers when you start talking about what is the significance of good faith in contract. Now, as all of us know, good faith is of minimal importance in common law, although there is a very interesting line of authorities now emerging from the highest court in England and Wales, which is starting to develop the doctrine of good faith in certain very limited contexts. But to the civilian lawyers, they will just say to common lawyers, what took you so long? We've had it for centuries, from the time of Roman law. So again, if you break it down into practical problems, let me tell you this story again from real life. I was once on a tribunal, and the governing law was New York law. But I was the only common lawyer on that panel, and the other 2 arbitrators were Indonesians, and Indonesia is a civil law country. Now, because it was New York law, I had assumed that they would pay some attention to my views as a common lawyer. Although I was not admitted to the New York bar, at least I had some idea of what common law principles were, subject to this very limited recognition of good faith under New York law. But because the civilians have lived with good faith as a foundation of their contractual law, they simply thought they could apply New York law in the same way as they would Indonesian law, where good faith was very important. So at the end of the day, I was overruled on the main issue of whether or not one of the parties that behaved in good faith. So these are things that happen and you have to adjust to it. So couple that with the other type of difference or cultural difference, and that is the seniority difference. There can be a very senior arbitrator against a very junior arbitrator. Usually the junior arbitrator is a little bit more respectful of the more senior arbitrators and will allow them at least to present the first preliminary opinion on any particular point, and then they will agree or disagree. But you also have people who are junior in a different way. These are people of a mature age. They may not have been lawyers in their primary profession. They could have been from a related profession like construction, or in maritime matters, they could be master mariners. And then they have taken courses in arbitration, so they have some understanding of the law. These are people who are successful in their own fields and have practical experience, and they are not going to be pushed around because they have experience in the field of construction or the maritime field, and they will have strong opinions. And you have to be very careful how you deal with these people, respecting their practical knowledge and their experience and their maturity, and not just say, because I have more years of legal practice than you, I'm entitled to speak first. It doesn't work that way, or it should not work that way. So when I am involved in that kind of a situation, I adopt what I would call an ambassadorial role as chairman, if I am chair, if not a very diplomatic role as what we call a wingman. A wingman, meaning you are a co-arbitrator and not the presiding arbitrator. And I go out of my way to make sure that my fellow arbitrators from different legal and ethnic cultures feel that I don't take their understanding and agreement for granted. Let me move on to the next level. That is, how do we deal with cultural differences or differences in legal tradition at the council level? Again, let me give you a practical example. I had a case. It was seated in Hong Kong, and the governing law was Macau law. As many of you know, Macau used to be a Portuguese colony. And so Macau law is very much based on Portuguese law. So the dispute was between a Hong Kong party and a party incorporated in Macau. So let's call him a Macau party. The Hong Kong party engaged a lawyer whose nationality and legal upbringing had been Singaporean. So he was actually a Singaporean, although I did not know him personally because he had migrated or he had moved over to Hong Kong for his practice for many years. So, but he was a common lawyer and he was from Singapore. So when he presented his case, the way that he presented it, both as a common lawyer and as a Singapore trained lawyer, was completely familiar with it. I understood completely where he was coming from, what he was saying, and how he was trying to prove his case. The party from Macau, they had engaged a very distinguished firm which sent 3 senior lawyers from Portugal to argue the case for them, because the Macanese law on this particular point, which was labor law, was based on Portuguese law. And one of the Portuguese legal team was so learned that he had been a former law professor. But their English was a bit different from normal common law trained lawyers. So I had some difficulty with understanding their explanation of the law, particularly in the way that they expressed themselves. So I had to learn a new law, Portuguese law, of which I had no experience, and also listened to it explained in a way that I was not familiar with. Their expressions were something which was unfamiliar to me. So in that sense, everything was going in favor of the Singaporean lawyer. But after the hearing was over, I went back and I reread the transcript. That's the arbitrator's best friend. The transcript, I read and reread it twice. And then at last, I realized what the Portuguese legal team was arguing. And I then understood the legal principles that they were explaining. And once I understood that, then I understood their case much better. And I came to the conclusion that on many respects, their case was stronger than that of the Singaporean lawyers. So it was a mixed result, but if I had not paid that extra attention to compensate for my lack of immediate understanding of where a civilian lawyer was coming from, the result would not have been fair at the end of the day. Mind you, Portuguese lawyers themselves had their own cultural prejudices. This manifested itself when we had to argue about the English translation of the Macanese law, which of course was in Portuguese and was translated into English, which was the language of the arbitration. And when the Portuguese lawyers criticized the translation, I said, but this translation was done by a certified Portuguese translator. And the Portuguese counsel, and I can remember it to this day, he actually spat out the words. And he said, in Macau, all the translators are from Brazil, without further elaboration. And to him, that was enough to devalue the translation. So the moral of this story is that an arbitrator has to take extra care and give counsel extra effort to ensure that he is given as much attention as you need to ensure that you have understood exactly what he is saying, so that you can then judge the correctness of his or her remarks based solely on the quality of the arguments. Let me now move to the third level, the witness level. Now, first, let's consider cultural differences. And let me again illustrate this by an actual story from my experience. I was hearing this case as sole arbitrator in Sydney. The dispute was between a Japanese party and an Australian party. And of course, in arbitration, all the witnesses give their evidence sitting down, as do the counsel. Now, the witness was speaking or giving his evidence in Japanese through an interpreter, who was another Japanese. And he was the respondent's main witness. And counsel for the claimant asked the Japanese witness this question, something to this effect. Isn't it true that you told the claimant that you agreed to accept this figure, a sum of whatever yen or whatever Australian dollar figure it was, in settlement of this case? And this question, of course, was very material for how the case was going to play out. Now, on the pleadings, he had already denied ever saying this alleged statement. And therefore, the answer that everyone expected from him was no. But the Japanese witness was sitting, then started to bow as he was preparing himself to give the answer. And everybody was wondering what's happening. Is he actually going to say yes? And then he kind of completed his half bow, his head almost touching the table. And he said, the answer is no. Okay, so at the next break, I got hold of the Japanese interpreter. I said, can you tell us, or tell me, sorry, this is a private conversation. Can you tell me why did the Japanese witness do this bow and give us the impression that he was going to say no? Sorry, give us the impression that he was going to say yes. And at the end of the day, he said no. So she said, look, Japanese normally bow when they want to say something serious, really serious. So I think he was trying to do a bow sitting down. So this is a sitting bow. So that stuck with my mind. And a few months later, I happened to meet some other Japanese lawyers in a different context. So I told them the story. And I said, what do you think? And he said, well, there is another explanation why that Japanese witness may have started to do this bow. And that is that he and the other party and the Australian party actually have been very close business associates. And I said, well, yes, that was the setting. That was a given fact. So the Japanese lawyers explained to me, he says, well, again, when a Japanese wants to say something which he knows will offend his very close business partner, he has to make it clear that he greatly regrets having to make this statement. And that is why he could have been bowing to express his regret to his business partner that, I'm sorry I have to say this, but the answer is no. Now, because I had already had the Japanese interpreter explain the mindset of the Japanese witness and the custom of the Japanese in terms of how they wanted to lay emphasis on a particular statement, I got the message. But it was important for me to understand that, to solve the mystery in my mind as to why that witness behaved in this way. Let me turn to another kind of factor that you have to take into account. There are no cultural differences, but there are those people who are what I call arbitration innocents or arbitration learners. They are either first time having an experience of arbitration or not very used to it. And they are also maybe for the first time giving evidence in any tribunal and maybe giving evidence in their own language, which has to be translated, or they may be trying to give it in English and that is not their first language. So give me yet another anecdote which illustrates the kind of problem. I was hearing an arbitration in New York many years ago. And I was a co-arbitrator, a party appointed arbitrator. The other party appointed arbitrator was an American, and the chairman was a British professor. All the counsel were US attorneys. And the dispute was between a European company who had manufactured a very complex technical system for a Malaysian party. So a European party against an Asian party, but both using American lawyers. I can't remember the governing law. It's not material for this particular thing, but the seat was Singapore, but the hearing was agreed to be in New York. And the parties had expressly written into their arbitration agreement that the hearing would be conducted according to the US federal rules of evidence and procedure. So in effect, it was like an American trial. And so all the counsel were engaged because they were US attorneys and used to the US style of running trials. One of the European witnesses came up. He was a senior engineer in the factory that had manufactured the system, which the Asian party was saying had been defective. Now, he was being cross-examined at great length by a very aggressive US lawyer who was giving him a hard time and constantly I considered to be very aggressive and confrontational, challenging every answer that the witness gave. I privately complained to our chairman that this was not fair to the witness. And everyone was silent while this was going on because all the American lawyers understood this is how things are done in US courts. And my British chairman just said, look, cross-examination should be robust. And so to him, that was acceptable. After we resumed again, there was this barrage of hostile questions that kept on coming out from the US attorney. And when I intervened, just to ask the witness, I'm not sure I understood your last answer. Could you just kindly explain that to me again? And he just said, I'm so relieved to find that there's someone in the room who does not question every answer of mine as not having been made in good faith. And you can imagine how that man felt alone in a foreign country, speaking in his second language, even though he was bilingual, and having to face, this US attorney launching into him the kind of cross-examination you are used to seeing on television. And if I had been chair, I would have done something different in controlling the tone and the aggressiveness of the questioner. So my view is that in all such cases, an arbitrator has to make all witnesses feel that they are being given a fair chance to present their case or present their evidence, especially if they come from a legal system, which itself does not place any great value on cross-examination. And some of you may know that in civil law systems, cross-examination is not a big feature. In fact, very often there are whole trials that go without any cross-examination. And when they do have cross-examination, it's usually very limited. So it's a whole new world for Europeans and people from civil law countries when they get into a common law court or a common law arbitral tribunal. And so I come back to this point that those of us who are arbitrators should consider themselves ambassadors for the role of international arbitration, which can only serve its purpose if it makes all of its users feel that the system is working and that the result of the arbitration has come about because of a proper, transparent, and fair arbitral process, even if they may disagree with the verdict. But before I end, let me leave you with one last anecdote to balance off what I've said. Again, a personal anecdote. At an international conference, when we were discussing how lawyers could contribute to better understanding of cultural differences in international arbitration, I made this suggestion. I said, can I suggest to the English barristers in this room that when they are cross-examining or making submissions, they do not use cricketing terms to make their points. Of course, that got a good laugh from all of the non-English. But at this point, an Indian lawyer stood up, and the Indian lawyer said, oh, it's okay. When they're arbitrating in India, everyone will understand. So I hope that these tips, which are based on real life examples, will help give you some insights that you will not find in your textbooks. May I wish all of you well in your future experiences in international arbitration. Thank you very much.
Thank you, sir, for your kind words. I would now like to call upon the Moot Court Committee to declare the results.
Thank you, Karan. Good evening, everyone. As a member secretary of the Moot Court Committee and to this event, I take an extreme pleasure to be addressing this very exciting phase of this 2 days event, that is the result declaration and the distribution of prizes. Now, I would like to begin my segment with a very wonderful quote by Mr. Vince Lombardi. He said that the price of the success is hard work, dedication to the job at hand, and the determination of that whether you win or lose, we have applied the best of ourselves to the task at hand. So, to the dear participants who have utilized their last 1 month in extensive research, litigation, discussions, online researches, and all, I would just like to say that, and I would also like to borrow from what Dr. Lalit Bhasin said just right now, that we all are winners because we have been chosen as the participating teams from our respective colleges and universities. So, we as the MCC committee believes that you all are winners, and to initiate now the result declaration and the other prizes that we had promised initially, I would like to request Samyak to share his screen. Samyak, thank you.
I hope so. My screen is
Yes,
visible.
yes, it is visible. Thank you,
Okay.
Samir. My this entire presentation, I would like to say this as a presentation because it would be divided into two parts. In the first part, I would be telling you the name of the winners and the runner-ups and the best memorial, the best speakers. And in the second half of the presentation, I would be telling you all the prizes that we had promised initially. So it would take a step-by-step thing, and then I'll be introducing it subsequently. So with the very first result, I would begin with the best memorial. So the best memorial goes to, and I would say that before I start giving out the respective prize categories, I would like to say that we had promised a sum of rupees 5 lakh, both in cash and kind, and we have successfully not only we won't be only be giving 5 lakh rupees, but also we have exceeded that as a promised amount, and we would be delivering as much as 5 lakh 32,000 the prize money. And let's start with the first prize, that is the best memorial. It goes to, the best memorial goes to the St. Joseph's College of Law, GDGU 405. Many congratulations to the team. Now the best speaker female goes to, now it's a very interesting tie. It goes to Ria Punamia from the Government Law College, Mumbai, and Shreya Mohanty, National Law University, Odisha. Many congratulations to both of you. You both had a really wonderful arguments that you had advanced in your preliminary rounds, and you both are adjudged as joint winners. Now coming to the best speaker male, it goes to Mr. Sri Vijay R. Shastri from Christ University, Bangalore. Many congratulations. And now coming to the final set of awards, that is the runner-ups and the winners, because ultimately these two teams had been really good with their advanced arguments in the final rounds, and all the judges were mightily impressed by their respective arguments. So the runner-ups of this competition is Symbiosis Law School, Pune. And the winners of this competition is Shastra deemed to be University, Chennai. Many congratulations. Now coming to the set of awards that we have promised and we are going to deliver as the GD Goenka University. Very firstly, SCC Online. The Supreme Court Cases Online has promised to deliver the following set of awards, which would be ranging from winners. The winners would be so as you can see, the total prize money of that would be delivered and that would be given by SCC Online would be close to 3,72,000. And also, like we had said, that no one is a loser over here. So we have collectively decided that to all our 60 plus participants, we are going to give a 1 month long platinum plus subscription of SCC Online. So there is no one who goes empty hand from here. Everyone gets something with themselves, and otherwise also you get close to 1,92,000 of cash prize from SCC Online to all the winners, runner-ups, and the best speaker female and male concerned. Moving to the next set of awards. So the Society of Indian Law Firms has also decided to give cash prize of rupees 1,40,000 in association with GD Goenka University. which would be amounting to winners. The winning team, that is the Shastra University, would be getting 70,000. The runner-ups, that is the Symbiosis Law School Pune, would be getting 40,000. Best female speaker would be given 10,000. Best male speaker would be given 10,000, and last, best memorial would be given the 10,000 rupees. Also, we believe that it is very important for an active and a clinical education earning. That is very important for all the students right now in this era of pandemic. So we have associated with MyLawman, and MyLawman would be giving the prizes close to 20,000 rupees, and that would be distributed subsequently to the winners, runners-ups, best speaker male and female, and as well as the best. That's it from me. Thank you.
Thank you, sir. I would now like to request Mr. Shreyas Vyas, faculty in charge of the Moot committee, for the vote of thanks.
Thank you, Karan. Vote of thanks is a moment of saying thank you to the people who guided, motivated, appreciated, supported, and worked hard. It gives an immense pleasure to propose vote of thanks on behalf of GD Goenka University, administration, committees, both at faculty and student level. Firstly, I would like to thank His Excellency Dr. Michael Wong, former Chief Justice of Dubai International Financial Center, DIFC, and Senior Counsel of Supreme Court of Singapore, Dr. Lalit Bhasin, President, India Branch, Senior Advocate, Supreme Court of India, President, Indian Law Society Firms, and Bar Association of India for gracing the occasion. I also extend my devotedly thanks to Mr. Samisha, Director Programs, SIAB India Branch, for helping us from start of the event and throughout the event and guiding us in all the circumstances. Thank you so much, sir. I would also like to thank members of our OC organizing committee, Mr. Chandrakant Kamdar, Honorary Secretary, SIAB India, Mr. Nusrat Hassan, Secretary, SIAB India, Dr. Dilip Virani, Treasurer, SIAB India, Mr. Vyapak Desai, Director, SIAB India, and partner Nishit Desai Associates, Mr. Tejas Karya, Director, SIAB India, and partner and head arbitration, Shardul Amarchand, for taking out time from your busy schedule and being part of the event and gracing the valedictory ceremony. Then I would like to thank all the judges of final rounds, Dr. Lalit Bhasin sir, Mr. Samisha, Mr. Ganesh Chandru sir, partner Dua Associates, Mr. Tejas Karya sir, and Dr. Joseph Aristotle, Honorary Secretary, Supreme Court, Advocates on Record Association, for taking out from time from your busy schedule and judging the final rounds. I would also like to thank you for encouraging our students and participants. I hope this competition will bring them in a long run of life, and it also help them to become an ethical legal professional, which is very important, as being pointed out by the legal luminaries present. I would also like to thank all the judges from all the rounds for sparing time from their busy schedule and judging all our rounds. I hope your suggestions and teachings would have helped our participants in their future professional life. Then I would also like to thank our Honorable MD, Mr. Nipun Goenka, for encouraging us for this event, as he strongly believes that law without practical knowledge is not of any use. So students should possess practical knowledge. So events like these encourage faculties and students to learn new things and aspects of life. Thank you so much for your support, sir. Then I would like to thank our President, Professor Dr. Sukku Bhaskaran, for gracing the occasion and supporting us with all necessary suggestions from his side. Then I would like our Registrar, Dr. Dhirendra Parihar, for extending all possible administrative support from his side. Now, the entire credit for conceptualizing this event goes to our Vice Chancellor and Dean, School of Law, Professor Dr. Tabriz Ahmed. Thank you so much, sir, for giving us a new dimension and helping us in discovering a new dimension to international commercial arbitration organizing skill, that is virtual. I thank you, sir, for all your support, guidance throughout this event. It was indeed a pleasure for working under you. Then I would like to thank Mr. Deepak Narayan, partner BDN Chambers, who has drafted such a magnificent proposition by taking all recent upcoming issues into the consideration. Then I would like to thank International Center for Dispute Resolution, ICDR, for allowing us to use their institution rules for this competition. A special thank to their director, Ms. Samriti Ramesh, for helping us throughout the competition and supporting us. Then I would like to thank Society for our co-partner for the event, Society for Indian Law Firms, by helping us in organizing the event and paying rupees 1 lakh in cash. Then I would like to thank our knowledge partner SCC Online by helping us in giving different prizes in different category worth INR 3072 lakh. Then I would like to thank our knowledge partner, My Lawman, by helping us in giving prizes in different categories worth INR 3,250. The entire detail of these prizes have been given by my colleague, Mr. Abhinav Kumar. Then I would also like to thank Ad Hoc for helping us in this event. I would like to thank our media partners, Policy Times, Locktopus, and Live Law, who promoted our event to their website and newspapers. We would also like to thank all the people from electronic media, print media for giving wide coverage to our event. I extend my earliest thanks to IT support given by Mr. Mohit, without whose help this telecast was not possible, and also helping us in telecasting our events on Facebook and other electronic medias. I would like to thank our designer, Ms. Paramjeet, for designing such beautiful posters and other related content for the event. I would like to thank my colleague, Mr. Pankaj Avasti and Abhinav Kumar of Core Committee, and my fellow colleagues like Professor Dr. Anil Davra, Dr. Anamma, Dr. Rakesh, Ms. Samriddhi, Mr. Sumit, Ms. Shrimpi, Meenal, and Mr. Brahmanand of School of Law, who help us in sailing throughout this event by sharing different responsibilities at different levels. And their contribution is valuable to us. I would like to thank our student committee under Ms. Mishali Poonawala and Mr. Sam Sharma, who worked day and night to make sure it is a perfect event. Thank you, Karan, for putting up such a magnificent presentation. I also thank all the participants for putting efforts. Winning or losing is secondary, but as our honorable guest said, participation is necessary. I'm sure this event make you learn many new aspects of law, which you will carry throughout your life. Thank you so much, every one of you, for listening. Bye. Thank you so much.
Thank you so much, sir. With this, we have come to the end of this valedictory ceremony. Thank you, everyone, for joining with us today. Thank you.